Hello everyone, and I hope you all are doing well. And welcome to the free online education platform of Purvanchal IAS. And this lecture is all about ethics, integrity, and aptitude, which is the part of your gender studies paper number 4. And in this series, this is lecture number 25, English version. And before proceeding to the main content, I would like to share some significant information here. So students, if you are interested for various study materials in the form of PPT or PDF, so you can follow the Telegram group. You can also follow the Facebook page of Dr. Ravi P. Agrari. You can join Purvanchal IAS at Gorakhpur for face-to-face and live classes. And for the correspondence courses and publications, you can contact on these numbers, visit the website, and you can also use our email ID. Let's move for the next. So here you are seeing a cover page of a book. This book is about ethics, Niti Shastra, and now they are available at Amazon and gyanworld.com. gyanworld.com. And the main thing is that this book will give you an abstract information about the entire content. So as per my good suggestion, please read it once, and along with this, please listen all the videos, all the lectures, and be continue with your preparation. On that note, let's move for the next. So here we are with our main content. So under the topic of ethics in public administration and probity in governance, today we are going to study the RTI Act 2005. Then we will see the RTI Amendment Bill 2019, and lastly we will see the topic whistleblower. So let's move for the next, and let us try to understand it one by one. So very firstly we will see the important act, which is the Right to Information Act 2005. So the Right to Information Act is implicitly guaranteed by the Constitution, and however with a view to set out a practical regime for securing information. Okay, the Indian Parliament enacted the Right to Information Act 2005 and thus gave a powerful tool to the citizens to get information from the government as a matter of right. And this law is very comprehensive and covers almost all matters of governance and has the widest possible reach, being applicable to government at all the levels like union, state, and local, and as well as recipients of government grants. So the Right of Information Bill was introduced in the Lok Sabha in December 2004. It was passed by both the Houses of Parliament with major amendments in May 2005, and then the assent of the President was received on June 15, and the Act was notified in the Gazette on June 21. The law will become operational by mid of October 2005. And this law was passed by Parliament to enable citizens to exercise their fundamental right to information held by public authorities all over the country except Jammu and Kashmir. The RTI Act aims to bring out the transparency in the functioning of public authorities, contain corruption and providing informations to the people, and apart from that they hold governments and their instrumentalities accountable to the people. And the RTI Act places a duty on officers to provide informations to people both proactively and upon request, and it provides for a two-tier, let me remove this, it provides two-tier appeals mechanism to deal with complaints of unreasonable denial of informations by public authorities. This law will have an overriding effect in comparison the Official Secrets Act 1923 and all other laws and orders passed by the governments that restrict information flow to the people, right? So the objectives of the act is to empower the citizens, to promote transparency and accountability, to contain corruption, and to enhance people's participation in democratic process. So once again, I would like to say that the basic object of the of Information Act is to empower the citizen ultimately and promote transparency and the accountability in the working of the government, contain corruption and make our democracy work for the people in real sense. It goes without saying that an informed citizen is better equipped to keep necessary vigil on the instrument of governance and make the government more accountable to the governed. The act is a big step towards making the citizens informed about the activities of the government. Right? Now let's talk more. So the geographically we can say it covers all of India except J&K, Jammu and Kashmir. So Jammu and Kashmir passed its own Freedom of Information Act in 2004. Remember this. And the jurisdictional is covers offices of the public authorities established, owned, or substantially financed by the central government, the state government, and the administration of the union territories. It will also include under the administration of the union territories is panchayats, municipalities, and other local bodies, and any body owned, controlled, or substantially financed by the governments is also included under the Right to Information Act 2005. This law will be applicable to all the NGOs, non-government organization substantially financed directly or indirectly by these governments. Okay, so these are the jurisdictional area of Right to Information Act 2005. And apart from this, information relating to a private body that can be accessed by a public authority under any law in force is also covered by the RTI Act. Correct? Let's understand it more on the ground of technicality. Let's take a plain page so I could make you understand better. So if we talk about the information, so what is information? So information means records, documents, memos, email, opinions, advice, press release, circulars, orders, logbook, contracts, reports, papers, samples, models, data, material held in in electronic form. So these are the information which is in the form of these form is included. So now next, let's talk about public authority. So a public authority is any authority or a body or an institution of self-government established or constituted by or under the Constitution or by any other law made by the Parliament or a state legislatures or by notifications issued or order made by the central government or state government. The bodies owned, controlled, or substantially financed by the central government or state government, and non-government organization substantially financed by the central government or a state government also fall within the definition of public authority. Right? And the financing of the body or the NGO by the government may be direct or indirect will also included or says that it comes under the public authority. Now next, what is actually right to information means? RTI, what stands for actually? What does it means? So the very first is, it is to inspect works, documents and records, correct? It right to take notes, extracts or certified copies. It right to take samples and right to obtain information in electronic form. I have explained you right now. And it is right to information whose disclosure is in the public interest. Correct? So information which cannot be denied to parliament or state legislatures shall not be denied to any person. This is the right meaning of Right to Information Act. And there's also a public information officer. So the public authorities have designated some of its officers as public information officers. They are responsible to give information to a person who seek information under the RTI Act. Okay, and there's also a assistant public information officer. So these are the officers at a sub-divisional level to whom a person can give his RTI application or appeal. These officers send the application or appeal to the public information officer of the public authority or the concerned appellate authority, right? And an assistant public information officer is not responsible to supply the information. Remember this, the assistant public information officer appointed by the Department of Posts in various post offices are working as assistant public information officer for all the public authorities under the government of India. Correct? Now let's talk Right to Information, RTI, Right to Information Act, and its some provisions. Okay, so a citizen has a right to seek such information from a public authority which is held by the public authority or which is held under its control. Just listen to me very carefully. And this right includes inspection of work, documents and records, taking notes, extracts or certified copies of documents or any kind of records, and taking certified samples of material held by the public authority or held under the control of public authority. Correct. So it is important to note that only such information can be supplied under the act which already exists and is held by the public authority or held under the control of public authority. Remember this. And the public information officer is not supposed to create information. Remember this. Or to interpret information. Both the work is not fall under the public information officer. They not have to do this, and they not have to solve the problems raised by the applicants or to furnish replies to hypothetical questions. So these are the work of public information officers. Correct? And the next is, the act gives the citizens a right to information at per with the members of parliament and the members of state legislatures both. So according to the act, the information which cannot be denied to the parliament or a state legislatures shall not be denied to any person. They shall not be denied. And a citizen has a right to obtain information from public authority in the form of diskettes, floppies, tapes, videos, or in any other electronic mode, or through printout provides such information is already stored in a computer or in any other device from which the information may be emailed or transferred to the diskettes or etc. Correct? Now let's talk about some of its important sections. So the very first is section 8 of RTI. So it mentions exemptions against furnishing information under RTI Act. So and 8 clause 2 of section 8 clause 2 provides for disclosure of information exempted under Official Secrets Act 1923 if larger public interest is served. So the act also provided for appointment of information commissioner at central and the state level both. It is information commissioner at the state and the central level. So public authorities have designated some of its officers as public information officers, and they are responsible to give information to a person who seek information under the RTI Act. And the time period, if we talk about the time period, so in normal course, information to an applicant is to be supplied within 30 days from the receipt of application by the public authority. If information sought concern the life or liberty of a person, it shall be supplied within the 48 days. And in case the applicant is sent through an assistant public information officer or it is sent to a wrong public authority, 5 days shall be added to the period of 30 days or the 48 hours as the case may be. Okay? It's not 40 days. I'm so sorry. It's 48 hours. It's full. I'm so sorry. I will repeat once again for you. So the information sought concern the life or liberty of a person. So in that case, it shall be supplied the information within 48 hours. Please, I'm sorry for the wrong here. And the subsection 1 of the section 8 and the section 9 of the Act enumerate the types of information which is exempt from the disclosure. Okay, so let's talk about what is not open, what is not can be open under the Act. So the very first is information that would prejudicially affect the sovereignty, integrity, security, scientific or economic interest and relation with the foreign state can't be disclosed. Information which would lead to commission of an officer, it is also cannot be disclosed to a person. Okay, and the information whose release is forbidden by a court or tribunal or disclosure which might constitute contempt of court. And the next is information whose release may lead to breach of privileges of parliament or state legislatures. So these kind of in this situations the information can't be disclosed under the Act. And if we talk more, then the commercial and the trade secrets, intellectual property, etc., and that that would harm competitive position of the third party, and the information available to a person in his fiduciary relationship, that is information shared between the client and the lawyer or the landlord and tenant or patient and the doctor. So in this situation also the information is not going to be disclosed to any person. Okay, and information received in confidence from the foreign government, and if information disclosure endangers the life and the physical safety of a person, and if it is about a source of information or assistance given in confidence of law enforcement or security purpose, so these are also not to be disclosed to any person, right? So these are some exempted situations. This cannot be disclosed under the Act of Right to Information. These information is not yet to be given to any person. Now, it's section 21. It scheduled that central intelligence agencies and the security agencies like IB, RAW, Directorate of Revenue Intelligence, Central Economic Intelligence Intelligence Bureau, Enforcement Directorate, and Aviation Research Center, Special Frontier Force, BSF, CRPF, ITBP, ITBP, CISF, NSG. These all are paramilitary force. Assam Rifle, it is also a paramilitary force. Assam Rifle, Special Service Bureau, CID Special Branch of Andaman and Nicobar Island, CID Crime Branch of Dadar Nagar Haveli, and the Special Branch Lakshadweep Police. Similar agencies established by the state governments will also be uh, included under the Act of RTI. But information relating to corruption and human right must be given, but only with the approval of the center or the state information commission, as the case may be. Okay, so they all are included for excluded. Okay, remember this, they all are excluded. These authorities or these institution related information is not going to give you by RTI. You will not take any kind of information under these authorities or institutions. The information related to these authorities is not uh, to be disclosed, right? Now, let's talk about its competent authority. It is section 2. Okay, so the Speaker of the Lok Sabha and the Center and the Vidhan Sabha in the state and the union territories is the competent authority. And the Chairman of the Rajya Sabha and the Legislative Council in the state, wherever it's applicable, and the Chief Justice of India and the Chief Justice of a High Court and Chief Justice of CJI of Supreme Court is the competent authority, and the President in the case of others authorities created under or by the Constitution, like the Election Commission of India, SCST Commission, Finance Commissions, etc., for the central level. Okay, and the governor at state level, administrator of union territories like lieutenant governor is also be the competent authority, and these competent authorities has the power to make rules for implementing the act within their jurisdictions. Okay, now let's talk about its supervisory mechanism. So the Central Information Commission, that is under section 12. So the Central Information Commission, that is CIC, to be constituted through the Gazette notification with immediate effect. CIC include one Chief Information Commissioner and not more than 10 Information Commissioner, IC. Okay, who will be appointed by the President of India. Oath of office will be administered by the President of India. Okay, and according to the form set out in the schedule, it will be based in Delhi. Other offices may be established in other part of the country with approval from the central government. Okay, and CIC will exercise in power autonomously without being subject to direction by any other authority. Correct? So these are the information about Central Information Commission, which comes under the section 12 of RTI Act 2005. Let's talk about its appointment process and qualifications, which is also comes under the section 12. Let me remove this. So the appointment committee includes Prime Minister, Leader of the Opposition in the Lok Sabha, Leader of the Opposition in Lok Sabha, and one cabinet minister to be nominated by the Prime Minister If there is no leader of opposition, then the leader of the single largest group in opposition in the Lok Sabha will sit on that committee. This is the situation. And candidates must be eminent person in public life with knowledge and experience in law, science, technology, social service, management, journalism, mass media, or administration and the governance. So they should be knowledgeable in this field to become an chief information officer. So one more thing is that no MP or MLA can be appointed CIC or IC, Chief Information Commission or Information Commission, during their term of service. They will have to give up that post upon appointment to the Information Commission, right? And under the section 13, terms of services provided for Chief Information Commission. So CIC appointed for 5 years, from date of entering the office, and IC will remit office upon attaining 65 years of age, even if the term of office is not completed. This is the situation. So CIC is not eligible for reappointment also, and term may be extended by 1 more year if recommended by the appointment committee. It will be extended by the recommendation of appointment committee only, and the salary will be the same level as that of the chief election commissioners. Okay, salary is same as chief election commissioners, and this will not be varied to the disadvantage of the CIC during the service. And if candidates is a pensioner at the time of appointment, so his or her pension will be part of that salary. Okay, and after the end of the term, CIC will be eligible for appointment to other office of the government. Okay, so the terms of service is also under the section 13. So IC will be appointed for 5-year term. 5-year term it is appointed for 5-year term, and IC Information Commission will remit office upon attaining 65 years of age, even if the term of office is not completed, and salary will be the same level as that of election commissioner, I told you, and this will not be varied to disadvantage to the IC during service. I'm talking about IC here, Information Commissioner. Previously, just before I had explained about the Chief Information Commissioner. Okay, so at the same, if candidate is a pensioner at the time of appointment for his or her pension will be the part of that salary, and IC is eligible for the appointment of CIC but will not hold office for more than a total of 5 years, including his or her term as IC. Remember this is the difference. And after the end of the term, IC will be eligible for appointment to the other office of government also. Okay, so I hope you all able to understand its technicality or the constitutional fact of this act. Okay, let's move for the next. And in 2019, the Modi government come out with the Amendment Bill of 2019, RTI Amendment Bill 2019. So right of information amendment bill has been tabled in the parliament, which seeks to amend the status, salary and tenure. That is status, salary and the tenure of the Central Information Commissioner and State Information Commissioner. So these are the basic amendment under the RTI Amendment Act 2019 comes out. Let's understand it clearly. So the proposed amendment is the Right to Information Amendment Bill 2019 seeks to amend Section 13, 16 and the 27 of the RTI Act 2005. Section 13 of the original Act, it sets the term of the Central Chief Information Commissioner and Information Commissioner at 5 years or until the age of 65, whichever is earlier. Okay, I explained to you. And it states the salaries, allowances, and other terms of services of the Chief Information Commissioner shall be the same as the Chief Election Commissioner, and those of an Information Commissioner shall be the same as that of an election commissioner. This is I'm sorry for this disturbance. And the next is, and in the 2019 amendment bill, it is proposed the appointment will be for such term as may be prescribed by the central government. It is the biggest change. And the salaries, allowances, and other terms of service of the Chief Information Commissioner and the Information Commissioner shall be such as may be prescribed by the central government. Okay. So basically, the proposed amendment allows the central government to control through rules the terms and conditions of appointment of commissioner in the states. So this is an assault on the idea of federalism. So that's why some of the activists, some of the lawyer is opposing this act. Okay. And of course, also the status of the Central Information Commissioner has been brought on par with election commissioners, and the status of the State Information Commissioner with the Chief Secretary in the state, so that they can function in an independent and effective manner, of course. And however, the amendment has neglected the recommendations of the Parliament Standing Committee that the information commissioners and CIC were to be made on par with the election commissioners and the CEC respectively, Chief Election Commission respectively. So the amendment empowers the central government to unilaterally decide the tenure, salary, allowances, and other terms of the service of information commissioners both at the center and the state level. So this is the amendment bill of RTI Act 2019. Now let's talk about the whistleblower. So a whistleblower is a person who could be an employee of a company or a government agency disclosing information to the public or some higher authority about the wrongdoing, which could be in the form of fraud, corruption, etc. So basically, they gives the information regarding some wrongdoing or some corrupted activities. Okay, a whistleblower is a person who comes forward and share his knowledge or any wrongdoing which he or she thinks is happening in the whole organization or in a specific department. A whistleblower could be an employee, a contractor, or a supplier who became aware of any kind of illegal actions or activities, right? So basically and generally, a whistleblower is a person who informs about a person or organization engaged in such illegal activities. And there's also a duty of the government so they could secure his life. It is very much important for the person who gives the information. Okay, that's why on this regard, a Whistleblower Protection Act, let me take a pen, Protection Act, it is a Whistleblower Protection Act 2014 is passed, and the act is provided at adequate safeguards against victimization of the person making the complaints. Okay, so it allows any person, including public servant, to make a public interest disclosure before a competent authority. The law has elaborately defined various competent authorities, and for instance, competent authority to complain against any union minister is the Prime Minister. Okay. And one more thing is that the law does not allow anonymous complaints to be made, and clearly states that no action will be taken by a competent authority if the complaints if the person who is complaining does not establishing his or her identity. Okay, so the maximum time period for making a complaint is 7 years. Remember this. So, lastly, I would like to say that the strengthening the whistleblower protection mechanism will help in ensuring that the integrity of the democracy is protected, cherished, and upheld. So, this is the last word of my lecture. I hope you will able to understand the both act, especially RTI Act and the RTI Amendment Act 2019. So I would like to say you thank you. Thank you so much for listening to me. And once again, I would like to recall you that join Purvanchal IAS for better experience. You can join it at Gorakhpur, and you can also join us on online platform. It is free of cost. And contact on these number for further information, for more information. So lastly, thank you so much. Thanks. Till then, goodbye. Be happy and keep happy.